Sexual and gender-based violence is a societal problem which expresses itself in a particular way on university campuses. The university has a unique role in society in a context like no other. We have undergraduate students, graduate students, faculty, staff, postdoctoral fellows, researchers, librarians, support staff, student services, human resources, and other administrative staff, and so on. Everyone is here for a common purpose, to work towards the university's academic mission. Among our undergraduate students, though, we have an age group that is statistically more vulnerable to SGBV. We have a diverse population with many cultural backgrounds and understandings. We have hierarchical structures which can both be conducive to SGBV and present a significant barrier to coming forward. Today, we're going to talk about the unique response required to address campus SGBV specific to our unique context. Many people mistakenly assume that we mirror the criminal legal system, but we are significantly different. You'll recall from the definitions of SGBV that some forms of SGBV may also be crimes under the Criminal Code of Canada. When an individual is subjected to SGBV, it's important for them to make their own decisions about who they want to tell and what they want to do. In order to make those decisions, they need to understand what each option entails. Survivors are often urged to go to the police as the right thing to do. The idea is that a police investigation will prove that the perpetrator is guilty of a crime and hold that person accountable to society while keeping society safe by putting the criminal in jail. The reality, though, can differ significantly from that narrative, especially for survivors, and many do look for alternatives. Making a disclosure at the university looks very different from making a police report. The university's SGBV policy is survivor-driven, meaning that a survivor can make decisions pertaining to themselves and their participation, and they have a number of options to choose from, including things like modifications, interim measures, personal support, safety planning, or making a complaint. The university's approach is more closely related to human rights law than to criminal law. It recognizes that SGBV is a form of discrimination based on protected categories, and that it acts to restrict access to campus activities such as learning, teaching, research, and work. In this framework, the university takes steps to dismantle barriers to access, for example, by preventing and addressing SGBV, and to provide equitable access to campus activities. We can start seeing the differences between a report to the police and a disclosure at the university right from the start when we look at the objectives of each system. The criminal system starts with a punitive orientation, with the goal of catching and punishing criminals to ensure that they pay their debt to society. By contrast, the university's focus is on the learning environment, which includes all university spaces, events, and activities, whether they're used for study, social interactions, or the workplace. The objective in addressing SGBV is to provide a safe, supportive learning environment free from violence, so each can achieve their role in our academic mission. One way to help us meet that goal is to create space for those who have caused harm to take responsibility and to be held accountable to those they've harmed. The university's orientation is corrective, not punitive, and aims to support those who've been subjected to SGBV with various options to restore that supportive and vibrant learning environment. The closest thing to a criminal report that the university offers is our complaint process, where an individual can report a violation of the SGBV policy. The differences between the two processes become apparent in that they are based in different kinds of law. Police reports are grounded in criminal law, which outlines how crimes will be punished. It holds the defendant accountable to the Crown, who stands in for society. The victim in the criminal system is a witness only, and the rights and protections are largely focused on the defendant. On the other hand, a complaint under SGBV policy is grounded in administrative law. The university creates policies to support its academic mission, which detail unacceptable behaviors which undermine the work of the university. In a campus complaint process, both the complainant and the respondent have rights. Both processes involve an investigation and a decision. In criminal law, it's called a verdict. In campus complaints, it's called a finding. And potential consequences. In criminal law, they're called a sentence. In campus complaints, it's called an outcome. Other and more detailed differences play out at a procedural level. A criminal conviction involves a police investigation, a judge, and sometimes a jury. The court can compel testimony from witnesses and issue subpoenas and other court orders. It has access to things like DNA testing to prove a case beyond a reasonable doubt, but it has strict rules of evidence and inflexible procedures. A criminal trial is also open to the public. University complaints should look and feel very different from a criminal process. They involve an administrative investigation and an administrative decision. Participation is generally voluntary, and statements are not made under oath. Procedures are more flexible, and a decision maker is able to consider any evidence as long as it is credible and relevant. On campus, a hearing can take a number of different forms, ranging from a document exchange to individual meetings with a decision maker. Both parties have a right to procedural fairness in a campus complaint. For SGBV complaints, the University of Alberta does not have a face-to-face hearing. Whatever form the hearing takes, the administrative complaint process is confidential and not open to the public. The reason for the strict rules and very high standard of proof is that a guilty verdict in a criminal trial could result in incarceration, that is, a loss of freedom. The public record of a criminal conviction can follow a person and affect the rest of their life. University processes are more fluid and flexible, and with that lower standard of proof, in part because the absolute worst thing that could happen is that the relationship between the university and the respondent could be severed. In other words, in the worst-case scenario, a student could be expelled or an employee terminated as a result of a policy violation. But there is no stigma in the form of a public record, there's no loss of freedom, and there's no authority to award financial compensation for damages. It is, again, the difference between a punitive and a corrective orientation. Because the objectives, procedures, investigations, and possible outcomes of criminal complaints are so different from those that happen on campus, the two processes can happen concurrently for those behaviors that are both policy violations and crimes. There's a significant amount of misunderstanding when it comes to the university's role in addressing SGBV. It's important to know that the university's job is to ensure that the learning environment is safe, supportive, and vibrant, and that all community members have equal access to that learning environment, regardless of their gender, gender identity, gender expression, or sexual orientation. While the university might impose discipline or sanctions in a complaint process, the goal of those is not to punish, but rather to correct the behavior and/or ensure that the learning environment is a place that is conducive to the academic mission.